Hello friends, in the series on the income tax cases, today we will discuss an issue on the additions of section 68. But before starting the deliberation, I want to discuss one point that whether in the income tax proceedings, the revenue can take the tax on the same amount. When we face various type of additions into the income tax proceedings, we came to know that there are some amounts on which the revenue is taking the tax on two times. For example, if as an assessee I have paid a commission of rupees 10 lakh to a person A, but in my assessment proceedings, the revenue adds that commission into my income by saying that this commission is non-genuine, the services has not been rendered, and I also accept that, and to avoid the litigation, I do not go into the litigation and pay the tax on that. So now the question arises that if this commission is added into my income, can the person to whom this commission has given can now exclude that amount from his income? Because the same amount has been taxed by Amit Gupta and the same amount has been taxed by the other person A to whom this commission is paid. The answer to this question is a big no. The A cannot say that you have made the addition into the name of Amit Gupta, so now the revenue should exclude this amount from my income. But this is not a straitjacket formula. There may be circumstances where the assessee can say that you have added this amount into the income of the other person. No. So that amount cannot be added into my income. This issue has been taken up by the Calcutta High Court in the case of Principal Commissioner of Income Tax versus Narsingh Ispat Limited, and this case has been reported in 463 ITR at page number 566. The date of the judgment is 11th March 2024. In this case, the assessee has received in the assessment year 12-13 share application money from H company. During the assessment proceedings, the learned assessing officer was of the considered view that the assessee is not able to prove the credit worthiness of H, so he added this amount into the income of the assessee. When the assessment proceedings were going on, the assessee categorically mentioned during the assessment proceedings that this amount was received by the subscriber H from whom the assessee has received this application money in the assessment year 9-10, and the revenue has already added that amount into the income of the subscriber H, and there is a direct correlation between the amount which was added into the income of the subscriber H in the assessment year 9-10 and the amount which has been received as share application money by the assessee in the assessment year 12-13. Friends, in other words, whatever the amount has been added into the income of the assessee in the assessment year 9-10 in the hands of H, the same amount was added by the revenue into the income of the assessee under section 68 in the assessment year 12-13. But the assessing officer was not agreeable with the point of the assessee, so he made the additions. The matter came to the CIT appeal. CIT appeal said that when the H has given the tax on that amount, then it is a conclusive proof that that amount has the credit worthiness and the assessee has proved the credit worthiness in respect of that amount. The matter travelled to the tribunal and the tribunal also upheld the order of the CIT appeal. In the same way, the revenue went to the High Court and the High Court also said that in the present case, the source of the share application money is explained itself at that point of time when this amount was added into the income of H in the assessment year 9-10, and there is a direct correlation between that amount which has been taxed into the income of H in the assessment year 9-10 and the share application money which has been received by the assessee in the assessment year 12-13. So, in the case of the assessee, the addition cannot be made under section 68. Friends, this is a very important case. at the end of this video. Once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Narsingh Ispat Limited, and this case has been reported in 463 ITR at page number 566, and the date of the judgment is 11th March 2024. Thank you, friends.